I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. A Wisconsin federal court has just dismissed a disgusting lawsuit that was filed by a MAGA extremist group trying to block President Biden's student loan forgiveness plan. Of course, Biden's student loan forgiveness plan would forgive student loans for those making less than $125,000, and loans about $10,000 in loans would be forgiven. For Pell Grants, it would be $20,000, is the essential summary of President Biden's student loan forgiveness plan. Well, this radical right-wing extremist group called the Brown County Taxpayer Association, brought by a legal group that calls themselves WILL, the Wisconsin Institute for Law and Liberty, one of these AstroTurf MAGA extremist groups that try to bring lawsuits against things that are incredibly important for addressing the concerns of everyday Americans. Anyway, they brought this lawsuit on Tuesday. The federal judge just dismissed the lawsuit on Friday and found that the Brown County Taxpayer Association had no standing by just saying that they were taxpayers and they were harmed by this because they'd have to pay additional taxes, which is not even the case. But the Brown County Taxpayers Association, they filed this lawsuit on Tuesday. They compared the situation to King George III, who imposed taxes on us without our consent. Notice this group was completely silent when Donald Trump passed his tax cut plan, which helped billionaires and cost our country about $5 trillion in the first year or two, and will cause us trillions and trillions of more. They had no way to pay for it, but these taxpayer association groups don't care about it when billionaires are getting tax cuts and that's increasing our deficit. But where they really care is when you have people like Joe Biden who have decreased our deficit by trillions of dollars and come up with a program that helps everyday Americans, like the loan forgiveness plan. But I digress. The real insidiousness of this complaint, the insidious nature, though, when you go to the causes of action that they assert violations of their equal protection rights under the Constitution. They go, violation of the equal protection doctrine. And here's what they say in paragraph 40. Biden created the one-time student loan debt relief plan with the express purpose of advancing, quote, racial equity, explaining that the purpose of the program is to, quote, narrow the racial wealth gap. The White House explained that the program is intended to help, quote, black students, black borrowers, and other borrowers of color. And then this group writes in their lawsuit, as such, defendants, Biden has articulated an improper racial motive in creating and implementing the one-time student loan debt relief plan. So here, this taxpayer association group, whose lawsuit got dismissed, argued that they were being discriminated against, that this student loan forgiveness plan, which tried to address in a very surgical manner systemic inequities, racial inequities in education, where the debt burden is higher on black communities and communities of color. This group argued that was racist to the taxpayer association and that their equal protections under the United States Constitution were violated. Fortunately, that was absolutely rejected. The federal court said, you don't even have standing to sue. Just asserting a general grievance that you are taxpayers does not give you standing. And these lawsuits have been filed across the country. And as the Biden administration said, look, if you don't want loan forgiveness, no one's forcing you to have loan forgiveness. So if you don't want it, just don't accept it. And groups that tried to sue that were the beneficiaries of this, they lost standing as well. But this taxpayer group clearly has no standing. This, according to Judge William Greisbach of the Green Bay Division of the U.S. District Court's Eastern District of Wisconsin, who made his order today on Friday. The group that brought this says that they are going to appeal it. They said this is an extraordinary case based on an extraordinary claim of executive power by the president. We are going to fight to the U.S. Supreme Court, is what they said. We don't want people to have student loan forgiveness. Only tax cuts for billionaires and let them trickle down to the rest of Americans. I mean, come on. But this equal protection argument that's being raised in that lawsuit on Tuesday, which was rejected here, is also an argument that the MAGA Republicans are making and have made to try to overturn the Voting Rights Act of 1965. There was a case this week before the United States Supreme Court, and the case was Merrill versus Milligan, which dealt with Alabama's racist gerrymandered map, where the population in Alabama is about 25% black. Yet there's only one of 7 congressional districts that have black representation, and the way the state was racially gerrymandered was to basically dilute the black voting power and consolidate it just in one district so that the state was not actually reflective of the population. And the argument made by the Alabama Solicitor General was something very similar, was an equal protection argument, and that they said, well, we're just trying to be race neutral here, and that by us factoring in a respect and trying to address the fact that blacks are underrepresented within the state, that is racist against the white community of Alabama, and that is a violation of our equal protection rights. And one of the arguments that Alabama made is specifically to overturn the Voting Rights Act Section 2, which talks about stopping discrimination through racist gerrymandered maps, because they claim that violates the Equal Protection Clause of the United States Constitution because it factors in race as a factor. And that's why the new Supreme Court Judge, Ketanji Brown Jackson, said, look, we need to look at what the Voting Rights Act is. We should look at what the 14th Amendment says and what the purpose of the Equal Protection Clause is. And we were trying, our founders, and what we were trying to do in the 14th Amendment was not race neutral. We recognized that there were systemic inequities and systemic racism in the United States, where the black population and other populations of people of color have been discriminated against in the United States. And so this was to create equality. It was specifically to address racism. So for you to say that addressing racism is itself a violation of the Equal Protection Clause totally turns the 14th Amendment, the Equal Protection Clause, the Voting Rights Act on its head. These were a major constitutional amendment, a major piece of legislation to address systemic racism. But you see here how MAGA Republicans, how this Republican Party is trying to use, how they're trying to utilize this Equal Protection Clause argument to basically say that efforts that try to address and combat racism are therefore racist towards them. Fortunately, this has been rejected. Fortunately, in the Supreme Court case, Merrill versus Milligan, well, unfortunately, it seems like the Supreme Court will uphold the map of Alabama. They're not going to go as far as what the Alabama Solicitor General wanted, which is basically to completely throw out the Voting Rights Act of 1965 and say that it's void and it violates the Equal Protection Clause of the Constitution. But they're going to uphold the racist map. It looks like we got to wait for that order to come out. But you see how these arguments are being used in both of those contexts. So I hope that update's helpful. But it was good news that the federal judge has dismissed this really despicable and disgusting lawsuit that was filed by this taxpayer association claiming that Biden's student debt forgiveness plan was, or student loan forgiveness plan was racist towards them. They had no standing in the first place. I'm Ben Meiselas from the MeidasTouch Network. Hit the subscribe button right now. We're on our way to 1 million subscribers thanks to you. Let's keep growing this together. Also, if you like this content and you want to support it, head to patreon.com/MeidasTouch, patreon.com/MeidasTouch, patreon.com/MeidasTouch. Until next time.
This November is Rowvember. MeidasTouch just released its brand new collection of Rowvember t-shirts and pins to let the country know what's at stake this upcoming midterm election. Go to store.MeidasTouch.com to grab yours. That's store.MeidasTouch.com.